Welcome to another video in the FX Tips series. Today we're going to talk about the benefits of the new foreign exchange legislation for companies. The new foreign exchange legislation brings a series of benefits starting with reduced bureaucracy. Some operations can now be done without presenting documents, simplifying the processes. There has been a significant reduction in foreign exchange codes, which are now found in Annexes 3, 4, 5, and 8. Additionally, there is no longer a need to sign the foreign exchange contract, further streamlining transactions. Now they are called foreign exchange operations. The new legislation also introduces new corridors in the foreign exchange market, expanding the options available to companies. One of these corridors is the non-resident account, or CNR, which simplifies financial transactions for non-residents. Another new feature is stablecoins, with regulation underway for their issuance by authorized institutions. We also have the international account, which allows authorized companies to maintain foreign currency accounts in Brazil, and EFX, or electronic foreign exchange, which facilitates large-scale and more efficient foreign exchange transactions. The legislation also allows the use of funds abroad for other purposes, offering greater flexibility. This includes loans and the payment of obligations between companies within the same economic group. A major step forward is the increase in the number of institutions operating as authorized foreign exchange agents. Banks and savings banks continue to operate without specific limits. Brokerage firms, securities dealers, credit, financing, and investment companies and development agencies can operate up to $500,000 per transaction per client. Payment institutions authorized to operate as foreign exchange agents can now conduct transactions of up to $100,000 per transaction per client. And virtual asset service providers, or PSAVs, can operate virtual asset services with some restrictions. For PSAVs, transactions involving cash are prohibited, and international transfers with virtual assets are limited to $100,000 when the counterparty is not an authorized institution. Another benefit is that there is no need for an inflow of funds for foreign currency loans or export prepayments, known as PPE. New regulatory thresholds have also been established for reporting foreign capital in the country to the central bank. The repeal of Circular No. 24 of 1966 and Resolution 4033 of 2011 grants greater autonomy to financial institutions. They can now allocate, invest, and direct funds raised in the country and abroad with more freedom, subject to prudential requirements. The advance receipt of export operation can refer to the export of the operation's debtor, its parent company, its subsidiaries, or a company controlled by its parent company. The fine for the ACC, Advance on Exchange Contract, is now limited to the value of the operation, and it has a maximum permitted period of up to 1,500 days. Finally, Foreign Exchange Law No. 14,286/21 declares that the institution authorized to operate in the foreign exchange market may not require from the client documents, data, or certificates that are available in its databases or in public and private databases with broad access. This measure reinforces deregulation and efficiency, preventing the requirement for information that is already known or public. In summary, the new foreign exchange legislation brings more simplicity, new opportunities, and greater security for Brazilian companies. It is an important milestone for the modernization and integration of Brazil into global value chains. Don't forget to subscribe to the channel and give it a like. See you in the next video.